Good morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case. We have one case on the docket here at 11 o'clock. I also have joining me on this panel Judge Jim Edwards from Seminole County and Judge Meredith Sasso from Orange County. It's the case of William A. Hans et al. Versus Jolie Thompson. I am going to assume that the appellant would like 5 minutes of rebuttal unless I'm told differently.
Yes, sir.
Okay. And just ask that anybody in the courtroom, if you have any devices that make noise, please put them on mute so it doesn't interrupt either lawyer when they're making their presentation. And Ms. Downs, are you making the presentation?
Yes, sir.
All right, you may proceed.
Thank you.
You're welcome.
Good morning.
Morning.
May it please the court. I am here today. My name is Mayanne Downs, representing the appellants in this action. Bill Hones, Marcellus Rambo Benson, Kathleen Hones, Jordan Reardon, Patrick Hones, and Mark Bernard. And we are here, of course, as appellants asking this court to reverse the final judgment entered by the lower tribunal and to remand for entry of judgment in favor of defendants in the action below. As the facts in both parties' filings set forth, Mr. Hones, Appellant Hones, and Mr. Thompson came together in the spring and summer of 2013. Mr. Thompson had an idea for a toy, not patented, but an idea for a toy called Surfer Dude that would ride the waves and come back to the person who threw the toy into the surf. Mr. Hones had a history of entering into startup companies, funding them, and successfully producing whatever goods or services those companies were in the business of providing. They entered into an operating agreement and agreed that they would have a 50-50 ownership stake in the company and that investors would come in over time, fund the company when it needed resources to proceed with patent, design, building, selling, and marketing this toy. Not long after the parties agreed to an operating agreement, Mr. Thompson injured himself in an accident. The Hones, Mr. Hones and Mrs. Hones, wanted to help him, and they lent Mr. Thompson up to $50,000. He could take down $5,000 a month for 10 months. They entered into a promissory note, and the promissory note stated that in the event that there was a default, and the date was December 31st, 2014, Mr. Thompson's interest in Toyosity secured the note, and that interest upon default would go directly to Mr. Hones. That is in fact what happened. As of December 31st, 2014, Mr. Thompson paid back zero of the note, didn't make any demand, didn't provide any notice, took no action at all, and by operation of law, pursuant to Chapter 609 Florida statutes and the terms of the promissory note, his interest went to Mr. Hones.
Do you see that promissory note issue as distinct from the collateral estoppel issue? In other words, do we need to reach collateral estoppel if this court agrees with your client on the issue of the promissory note transferring the interest?
I believe it's an independent reason the final judgment must be reversed because, as we'll get to shortly, ultimately, the lower tribunal in Brevard County said, hey, the law doesn't work that way. You can't agree in a promissory note to just retain collateral. That is, of course, directly contravened by Chapter 609. And so the final judgment, independent of the collateral estoppel issue, has to be reversed because it's founded upon this notion that you can't retain collateral under law, when of course you can. And societally, that makes the best sense. We don't want people to sue if they don't have to. We don't want them to breach the peace. We don't want them to involve the judiciary unless it's necessary to do so. But let me add a little bit more, Judge Sasso. Independent of that failure to follow Florida law, under the final judgment we're here about today, there is an independent issue that speaks to the frailty of the final judgment, and that is that in the action in 2015 in Orange County, the promissory note issue and the extinguishment of Mr. Thompson's interest in Toyosity down to zero, not $1, not a share, nothing, zero, was fully adjudicated, litigated, and then adjudicated by Judge Munyon in the Orange County 2015 determination, trial, and final judgment. So there is some relationship factually, but our position is that the promissory note has two impacts on the final judgment. Final judgment's wrong because you can retain collateral, and that's what the parties agreed to, and the law requires us to respect that agreement unless there's some other reason not present here. Independently, the adjudication of the 2015 Orange County action said, Mr. Thompson's out. He owns nothing.
I'm going to go way out on a limb here and predict
Yes, sir.
that the appellee is going to say, Judge Munyon said, I'm not determining ownership, therefore it's not critical to the judgment and the finding in that case. I know that's a big leap, but...
Big
so
jump.
go ahead and why don't you, since we're talking about that, why don't you go ahead and address that?
Well, Judge Edwards, I'll address your outlier crazy issue there, of course, and that's been a central theme of the writings. And in our final brief, we had to go through a somewhat sloggy recitation about why that argument that was made by Mr. Thompson in his answer brief was misleading. And the reason it was misleading is that at the beginning of that action, day one in 2015, in fact, in response to an argument about evidence and whether evidence would come in. And by the way, Mr. Thompson got a lot of evidence in. He did a good job in that matter representing himself. But in response to an argument about relevance and admissibility of evidence, Judge Munyon said, hey, this is an injunction action. I'm not going to be deciding what you just said, who owns the corporation. Actually, she said it twice. The first time she was talking about a totally separate corporation, Con Air, which is where the parties were leasing office space. But after she made those comments, and because Mr. Thompson wanted to talk about capital calls and the operating agreement and the promissory note, and I got hurt because all of that ended up coming into evidence because Judge Munyon properly deferred to a pro se litigant and let a lot in. The plaintiff, in that case, Toyosity, in privity with Bill Hones in this case, said we want to conform the pleadings to the evidence. And in fact, in making that argument before the court, Toyosity specifically said, we want to be sure that the evidence about the promissory note and the fact that the default of the promissory note meant that Thompson had no interest after 12/31/2014, we want to make sure that's in evidence and that our pleadings conform to that evidence that was admitted.
But Judge Munyon could have issued that injunction whether he still owned his share of the company or not. I mean, once you've assigned your right to the patent to the company, you can't run around and sell the same toy and act as though it's yours to sell. I mean, so she could have reached the same decision whether or not he had defaulted on the promissory note, couldn't she?
She could have reached the decision about Mr. Thompson's actions vis-a-vis the ownership of the patent. However, she made additional findings. She made findings that not only was Mr. Thompson acting in derogation of the fact that he had transferred the patent to the company, but that in addition, because he had no legal rights in the company, because he wasn't an owner, and his position in the trial is, I'm an owner, you took my stuff. I was supposed to be a 50-50 owner. So she made the additional adjudications and findings that he had no legal right to undertake all the other actions he did, saying that he was the owner, offering a $10,000 challenge. There's a lot that's set forth in that final judgment in the injunction. So you're right in that had the parties only brought in evidence of and had the only challenges to the plaintiff's position focused just on the assignment of the intellectual property, then I think you would be right, Your Honor.
Right, but when, under collateral estoppel, doesn't it have to be critical to the decision or necessarily adjudicated in the first proceeding to be binding or issue preclusion in the second?
Well, as you know, there's a lot of different ways to describe that. Yes, it can't just be a passing or stipulated matter or something that really, let's say, is prefatory or only, somewhat slightly related. But here, and I personally love the way the Fidelity Insurance Rice case describes it because it's kind of not legalese. And that court says what you look at to determine the materiality of the issue is what were the points and issues that were disputed and decided by the prior litigation. And to me, that's the cleanest, simplest way to understand it. And so what Judge Munyon did in her order is go through, yes, there was an operating agreement. Yes, it's valid and enforceable. So is the promissory note. You lost your rights under the promissory note. She also addressed the patent. You know, it's a short order. It's 4.5 pages. There is not a lot of extraneous windup in that order. It gets right to the point. But the findings and adjudications about the promissory note, the default, and the fact that after 12/31/2014, Mr. Thompson owned nothing, were key to, a part of, and written right in that final judgment. Not as, again, prefatory matters, but as matters of fact and law. And so we jump forward to the
As far as the ownership,
Yes.
the addressing of the ownership, am I correct, Ms. Downs, that that never appeared anywhere, obviously, in the complaint, anything initiating the lawsuit? It was only at the final judgment stage when that information was placed into the pleadings. Is that correct?
I'm not sure I'm exactly following. Let me answer it this way, and I know you'll tell me if I'm not addressing your question. Both parties moved for summary judgment. And in those motions for summary judgment, they went through all the issues that had both been established by this time they were up to a 4th amended complaint. A DEC action, by the way, a 4th amended complaint, and the discovery that had occurred. And so the issue of the promissory note, the fact that the pleadings were expanded by the introduction of evidence and the grant of the motion to conform the pleadings to the evidence, all of that was in the motion for summary judgment. Now, it is absolutely true that the way the plaintiff in Brevard articulated their claim left the promissory note off to the side. They focused on, oh, there was a capital call, oh, we couldn't afford it, oh, there was a big conspiracy to deprive me of my interest or reduce my interest to 4%. But all of that is belied by, trumped, adjudicated, and taken care of by the fact that by the time the lawsuit we're here about today was filed, Mr. Thompson's interest had been long extinguished. By the way, Mr. Thompson knows how to file an appeal. He appealed 4 or 5 matters between Orange County and Brevard, but not the final judgment that said, you're out, sir. You lost your interest. You defaulted. It's over. And so,
Can I go back to, you mentioned privity of the defendants with the last, and specifically Hans.
Yes.
And I think the brief goes through his control of the prior litigation. Is that your argument as to all the defendants named in this litigation, or is there a separate theory for why every defendant is in privity with Toyosity in the initial litigation?
well, that's a good question. The additional defendants are in this case because after Mr. Thompson lost his interest in Toyosity, Mr. Hones, who was then the president and CEO, and Mr. Benson, who Judge Munyon found had a valid 5% interest, because that was before her too, operated the company and brought in additional investors and additional people, and those are the additional owners of Toyosity that you see that are here in this case. It is our position that the adjudication made by Judge Munyon that Thompson was out applies because of the identity of interest. Toyosity was the plaintiff in Orange County. It was Mr. Hones was the CEO, the president, and the sole manager of Toyosity at the time of that 2015 trial. Everybody else came in afterwards, but we don't need to have collateral estoppel for each and every one of those parties because they came in after Mr. Thompson's interest was extinguished. So vis-a-vis this case, Hones versus Thompson, that determination in 2015 by Judge Munyon and that final judgment took Mr. Thompson out of the equation. Another problem with this final judgment in Brevard that we're here about is when the final judgment says, hey, Mr. Hones, you couldn't obtain Mr. Thompson's interest unless you filed suit. Talked about that. The net effect of that is that all the other parties who invested in the operation, put their money in, put their services in, they get wiped out retroactively after the fact by virtue of this flawed final judgment.
Ms. Downs wants you to know you're in your rebuttal time, so I don't know.
Okay, then I will see you in a few moments.
Okay.
Thank you.
Morning. You may proceed.
Good morning. Mike Riemenschneider for Mr. Thompson. May it please the court. I was at the summary judgment hearings and have been involved in the case for probably 2 years. The first thing that I wanted to focus on was that counsel said that the promissory note or the collateral was in the possession of Mr. Hones. Typically what happens in a stock transaction is you turn over the stock as part of the secured collateral. There was no turnover of the units that Mr. Thompson had to Mr. Hones. In fact, the promissory note states very specifically that Mr. Thompson has to transfer the units over to Mr. Hones. And there was no evidence in the summary judgment hearing that there was any transfer of the units to Mr. Hones at any time, and that he has to put them on the books and records in order for them to transfer properly. And there was no evidence that was...
What's your authority for that?
What's my authority for what?
That there has to be some documentation of a transfer in order for there to be a determination that interest had transferred pursuant to a promissory note in light of Chapter 609.
The promissory note itself, the language of the promissory note itself says it has to be registered on the books and records of the company in order for the transfer to occur. That's what I'm relying upon, not on any particular statute. It says that it has to be on the books and records. There were no books and records that were in the summary judgment hearing. There was no...
So your argument is that as a result of this, that the interest did not transfer pursuant to the promissory note?
That's correct. That's correct. That's part of it. Yes, ma'am.
How is that consistent with the plain language of the promissory note?
Well,
It transfers without the need for judicial intervention and that sort of thing.
Well, I think it's still, what it says is that it has to be transferred, and I'll get it in front of me and read it. Borrower will promptly, with an effective date no later than December 31st, 2014, transfer to holder that portion of borrower's equity interest in Toyosity, a Florida limited liability company, as represented by the percentage determined by dividing, and it goes on from there. So it's
It goes on
actually,
and says the borrower authorizes the holder, the lender,
it goes on to say that,
to
yes.
transfer it without any further action of the borrower, so it doesn't actually require the borrower. I'm looking at the bottom of Exhibit D.
Yes, sir, I got it. Yes,
Yeah,
sir.
I mean, I still see where it talks about the records and books, or the books and records of the company,
Yes,
but
sir.
there's no absolute requirement in here that the lender, the holder, has to wait to actually get the stock certificates in his hand, is there?
Well, I think that the language is somewhat diverse from one another, because it says clearly on one paragraph that he shall transfer it. That tells me that there has to be a request and there has to be a demand, which there wasn't.
He wouldn't be the first person not to turn over his stock when he failed to pay. So doesn't the second paragraph kind of deal with that? The lender can, I understand still, if there was no book entry, I understand your argument may still be fine, but.
Sir.
I
Yes, sir, I understand your argument as well. I think that they divert from one another as they go along. But still, there was no books and records that was introduced into evidence at the time of the summary judgment.
Let me go back, though, because the final judgment, the basis for granting summary judgment, denying opposing parties summary judgment, was that the parties failed to, or Hans failed to enforce it via lawsuit. Do you agree that under Florida law, it was not necessary to bring a suit to enforce a promissory note?
I think that it was required to bring a lawsuit on the security interest because they did not comply with the satisfaction of collateral by collateral in the actual statute itself. I think
So how is that consistent with 679-601?
679, 601, or
609,
610.
sorry.
610 talks about the issue of taking the property and having it satisfied, and the collateral satisfies the debt. However, it goes on to say that you've got to send over a letter, some sort of notice, making...
Right, but so when we go to notice, the statute also lays out remedies. It does not, in other words, nullify the fact that the promissory note required transfer. There might be remedies, a limitation on pursuing a default or
A
deficiency judgment, for example.
Right,
But this concept in the final judgment, because we're looking about whether there's reversible error in the final judgment, of the requirement that a suit be brought in order to enforce a promissory note, you would agree is inconsistent with sections 679 and 609, that parties can take possession of collateral without judicial process.
I think the parties can take possession without process, yes, but I think that you have to follow what it says in the statute. And what it says in the statute is you have to give notice, and you have to say that you're going to keep the property and give us 30 days in which to say we want the property sold. And if there's a surplus, that surplus be paid over. They didn't comply with any of that, and none of that was in the record. So,
Well, I think none of it was in the record.
None of it was
So
in the record.
there's also nothing in the record that they didn't comply with it. Correct?
there's nothing in the record that shows that they complied with it. There's nothing in the record that shows they didn't comply with it, but I think they had an obligation to come forward and...
So that might be a separate issue if, for example, this was a suit on the promissory note. If there was a suit brought pursuant to, 679, 625, for failure to provide notice of retaining collateral, that might be a separate issue. But in the context of whether or not Mr. Thompson lost his interest in Toyosity by virtue of failing to repay a loan, when you agree that it was error then to say that that is only true if there was a lawsuit brought by Toyosity or by Mr. Hans to enforce the promissory note.
No, I think that the error goes back to the Munyon case, if you want to go back that far. I don't think that, I think I've made myself clear on the issue of the fact that they didn't satisfy the statute by providing notice. Therefore, I think at that point they had the only remedy available to them was to act reasonably, commercially reasonable under the circumstances, which would be, in my view, a sale of some sort, or either a private sale or a public sale, but do something instead of just hold on to it without providing any notice at all.
So you think your client is excused from repaying $50,000 based on this argument about commercially
I think
reasonable disposition of the collateral?
I think that he is exonerated from paying $50,000 for 4% of the collateral. The collateral had been diluted improperly back in 2014. So, you know, if he was going to pay $50,000 for 4%, I think that you have to look back.
It's not though paying $50,000 for 4%. It's repaying $50,000 that he was loaned. The collateral might be insufficient to secure the lender's interest under that argument, but it doesn't.
But the case law says, look, Mr. Holmes was the wrongdoer here. He reduced improperly the percentage of collateral that Mr. Thompson owned in that company. He caused the situation where we were buying the property back for $50,000 for a 4% interest. I mean, he took benefit of his wrongdoing, basically, and the case law is pretty clear.
He got the $50,000, $5,000 per month, and agreed to repay it. So, I mean, if we stop there, that's totally accurate, correct?
That's correct, Judge.
And it's accurate, he did not repay it.
He did not.
And the promissory note provided that his ownership interest, not 50%, not 10%, 20%, whatever his ownership interest, was the collateral which would be forfeited, correct?
That's what it said, yes, sir.
Okay, so he signed that and agreed to abide by that until you say he was done wrong with the dilution of his stock by the other people coming in, correct?
Yes, sir. Yes, sir.
And you say the error is in Judge Munyon's final judgment, but it was not appealed. I mean, that's, I guess here we are in collateral estoppel land, but...
Well, I think you're dealing with collateral estoppel. I think you have to look at the fairness of the proceeding, and the proceeding has to...
In other words, anytime a pro se is involved, it's per se, don't worry about taking an appeal?
No, sir. That's not what I'm saying at all.
Kind of what Judge Jacobus said is, they were treated unfairly, they took advantage of him, submitted a final judgment that they denied they submitted. I mean, that's all bad and a reason not to apply collateral estoppel.
I think that the fact of the matter is that Judge Munyon said repeatedly, and you have already, quoted the fact that she said repeatedly that this case is not about ownership. I'm not making a decision about ownership. Even when they conformed the evidence at the very end of the case in chief, she said, I'm only conforming as to the injunction. She did not say that I'm conforming across the board. How is a pro se defendant in that situation? I realize they're not entitled to, special help, but the fact of the matter is, how is Mr. Thompson, who's been told by the judge, we're not going into those areas?
But yet she did.
But yet she did. And he tried to go into those areas, and she stopped him. Repeatedly, she stopped him. And I have the cites to the record if you need those.
I'm not doubting that, but I'm saying in the final judgment from Orange County, it says, it discusses that, the 5% came basically equal from both of them. There's a lot of things in that Orange County judgment which I understand by saying I'm not deciding ownership, but then she does, and your client doesn't appeal it. It may be harsh to expect a pro se person to do it, but what's the opposite? Every time a pro se is involved, that kind of, you get a pass?
Well, I think that he had the right to bring an action in Brevard County against Mr. Holmes and Mr. Benson, and as part of that, the other side raised res judicata and collateral estoppel. Those issues were before the court, and collateral estoppel was an issue that the court dealt with and passed on, and did make a finding that perhaps the fairness of the proceeding was not up to snuff. But that's what the Brevard County Court did, and he dealt with the issue specifically. That was the argument at summary judgment, was collateral estoppel and res judicata.
Isn't that a misconception of the law, though, on fairness? It's in terms of collateral estoppel, whether there was an equal opportunity doesn't necessarily equal opportunity to present evidence, but whether it was procedurally equal in the sense that each party had the opportunity to present evidence and the opportunity to appeal. The cases in which there's a finding that a prior litigation wasn't fair is when for some procedural quirk there was not an appeal available, for example.
Well, I think this is an extraordinary situation, to have a situation where Gray Robinson is allowed to put on every bit of evidence they want over the objection of Mr. Thompson, and yet when Mr. Thompson tries to put on evidence of the ownership, he gets stopped, and the objection gets sustained, and he gets stopped along the way. So I think, no, the proceeding wasn't fair.
And that might have been a due process argument you would have made in the prior lawsuit, but when you look at collateral estoppel and whether there was a full and fair opportunity to litigate, that contemplates some categorical procedural categorically that some procedural wasn't available, as opposed to specific legal errors in the consideration of the prior claim.
The Goodman case cited at 804 Southern 2nd 544 says that there must have been a full and fair opportunity to litigate that issue. And it says that the issue must have been critical and necessary part of the prior determination. The issue of the promissory note and who owned the promissory note and who was the owner had nothing to do with what was going on in the Munyon case. I mean, the Munyon case was very clearly dealing with whether he had violated the injunction or not, whether he had violated the patent or not, excuse me. So I don't think it's just a procedural issue. I think it's an extraordinary situation when you've got a case where you have a litigant, even one who's represented, who is told basically not to go into areas that have already been covered by the other side, and then at the end of the day, everything gets changed around through a motion to conform, which also is limited by the court to the injunction itself and not to a broad range of findings. I think that you have a collateral estoppel issue, and that's why I think we prevailed on the case. So with that,
Counsel, you weren't representing your client in the Orange County case, correct?
I was not, sir. No.
Okay, you were part of the Brevard County case.
Yes,
correct?
sir. Yes, sir.
So what evidence are you aware of that was presented in the Orange County case that was the basis for the statement by the trial judge in the Brevard County case that there is no doubt that Toyosity and Gray Robinson took advantage of the pro se defendant?
The judge did not elucidate what he was referring to. I can only speculate.
Well, that's concerning because the word no doubt is used specifically to describe what happened in the Orange County case. So can you give me any hard facts or admissible evidence that was the basis for that statement from the trial judge in the Brevard County case?
All I can do is tell you speculation because I wasn't there, and I have read the opinion. I can certainly tell you what I think, but it is certainly not within the purview of what you have limited me to.
Okay, and then what about the statement by the trial judge in the Brevard County case that even though disputed by Gray Robinson, PA, the executed final judgment of injunction appears to be prepared by Toyosity and Gray Robinson, PA?
First of all, I don't think the court makes a statement that he's certain about that. But secondly, what happened in the hearing on the summary judgment is Mr. Aaron admitted that Gray Robinson had done the final judgment, and while we were arguing and discussing that issue back and forth, Mr. Aaron, quite remarkably, got on the phone and called Mr. Zimmerman at Gray Robinson and got the answer. And apparently Mr. Zimmerman told Mr. Aaron, who told the judge he had nothing to do with the drafting of the final judgment. So there it is.
Is that simply counsel prepare a proposed final judgment? Is that the basis for that claim, that Gray Robinson prepared the final judgment?
Well, I think that's the basis of the claim, is that what Mr. Aaron said during the summary judgment was that it was prepared by Gray Robinson.
Well, and do we know that the the final judgment that was actually prepared in draft by the opposing counsel, that was signed lock, stock, and barrel
I
without
do
any
not.
correction?
I can't tell you that, sir. I don't know.
And wasn't that corrected? There was a discussion, and it was in response to the judge's question about whether or not this was prepared and to what degree, and it was clarified in response to the judge's question, to Judge Jacobus's question, that it appeared
Clarified
Judge
on the
Mannion-
telephone. I mean, come on, it was a telephone conversation that I was not a part of, that I did not hear, that I had no ability to cross-examine anybody on. It was a telephone conversation during a summary judgment hearing.
In your view, is this relevant then to the issue of fully and fairly litigated by virtue of the fact that there could or could not have been a proposed order prepared by a law firm submitted to a judge in Orange County?
No, I think that they could
That
have...
would take out a lot of cases.
That would take out a lot of cases, certainly, certainly. I'm just trying to speculate on what the judge was referring to. I don't know exactly what the judge was referring to. I can tell you what happened while I was sitting there, and what happened was it was admitted that it had been prepared by Gray Robinson, and then ultimately on the phone call it was admitted that it had been changed
During the same hearing?
during the same hearing.
So pencils should no longer have erasers because nobody's allowed to make a mistake?
No, I think that's fine, but, you know, I've been doing this for 35 years. I haven't had anybody during a summary judgment hearing pick up the phone and call somebody else. I mean, I think that's a pretty...
Did you plead in your motion for summary judgment that because Gray Robinson, sorry, I go back too far with
Yes, sir.
that,
Yes, sir. Yes, sir.
that they prepared the draft
No.
final judgment?
No,
Did you plead that?
No, sir. I
Then
didn't.
why was it even discussed during a summary judgment?
I don't know. You'd have to talk to Judge Jacobus. I don't...
No, I don't need to talk to Judge Jacobus. You're trying to rely on something that shouldn't have even been brought up during the summary judgment hearing.
He brought it up. I think, you know, he's
He
made...
brought it up out of thin air. Somebody gave an initial response, and then to make sure they were correct, they called to verify it and verified it and corrected, I'm sorry, I was wrong. We didn't submit the judgment, but they're not allowed to do that.
Well, I think it's pretty extraordinary. Whether they're allowed to do it, I don't know if there's any case law on it anywhere.
I'd be shocked if there were.
I would be shocked if there were. Thank you.
Thank you, counsel. Ms. Downs, you have 4 minutes and 18 seconds.
Can you address the argument that there wasn't a specific procedure following the default, and so therefore Mr. Thompson retains his interest in Toyosity?
Yes, I can tell you that that actually is in the record in the motion for reconsideration after the non-final order that Judge Jacobus entered. In the motion for reconsideration, we presented the books and records of the company showing that notice was given and that the transfer was entered on the books and records of Toyosity. That, of course, is fundamentally irrelevant to this appeal because the only consequence had notice not occurred, as you point out, Judge Sasso, is that Mr. Holmes would have been potentially prevented from a deficiency judgment. The note itself says if you default, your interest transfers to Mr. Holmes and the debt's wiped clean. So deficiency was never a part of the matter. Judge Edwards, we were talking earlier about the criticality, the points and issues, you know, implicit in a part of Judge Mannion's order. And my colleague reminded me of an excellent point, which was a third order, part of the order of injunction against Mr. Thompson, was that he was ordered not to interfere with any operations of the business. And that has, you know, that's a very separate issue than the patent. That's, yes, you were a part of it, you defaulted, you're out, stop it, don't interfere. Of course, the next thing he does is files this lawsuit. And, you know, fast forward, potentially the next appeal is he's running the company and about $1.7 million has gone into a trust account, but that may be for another day. I also wanted to make a note that the standing argument, which we didn't talk about, I just want to say briefly, there's a lot of toing and froing in the brief about whether standing was preserved, but it was affirmatively defended in the answer to 4 amended complaints when we said repeatedly, Mr. Thompson he has no stake to be here. He doesn't own any interest in Toyosity, and he can't be here for anything other than, I suppose, he could have been there for a fraud claim had not the issues been litigated before Judge Munyon. I also want to note that in addition to the collateral estoppel failure, we say, of the trial court below, the trial court below rejected collateral estoppel, not on any traditional legal analysis, but the final judgment actually says that Judge Munyon's final judgment should have been strictly based on the allegations in the complaint and the cause of action. So he acted as an appellate court. And also, another issue we haven't talked about, he also acted as a fact finder because the 2 parties filed affidavits. By the way, Judge Jacobus never heard a single word from Mr. Holmes or Mr. Thompson. Judge Munyon heard from all of them and put in the first sentence for order that she made a judgment on their credibility. I think all of this attack on individual lawyers and law firms is unseemly, and it's uncomfortable to have to address it. It's immaterial. But I just want to note for the record that my partner, Jason Zimmerman, filed an affidavit after that summary judgment hearing to point out we did not give a proposed final judgment. Judge Munyon specifically said, I write my own orders. I don't even want to see a proposed order. Mr. Remenschneider said at the hearing, and he actually supplemented the record on this appeal to put this in so he could argue it. He said a proposed final judgment from Gray Robinson was on Judge Munyon's desk before Mr. Thompson got home from the trial. That never happened. Judge Munyon doesn't take proposed orders. We didn't submit one, and that was an unseemly and inappropriate thing to have argued, and certainly to show up in a final judgment. So respectfully, we request you reverse and remand with entry of judgment for defendants. Thank you.
Thank you, counsel. It was a well-argued case. Thank you for your arguments, and we're adjourned.